Question number 551. Which of the following is not a secondary evidence? Certified copies of a public document, copies made from or compared with the original, counterparts of a document as against the parties who did not execute them, oral accounts of the contents of a document given by some person who has himself not seen it. In question number 551, correct answer is option D, that is oral contents of the documents of a given by some person who has himself has not seen is not a secondary evidence. Question number 552. Out of the following, which is not a secondary evidence? Copies made from the original by mechanical process, copies made from or compared with the original, oral accounts of the contents of a document given by a person who has himself seen it, oral account of a photograph. Here in this question, it has been asked which of the following is not a secondary evidence. Correct answer is option D. Oral account of photograph is not a secondary evidence. Question number 553. Oral account to the contents of a document by a person who has seen it. Testimonial evidence, primary evidence, secondary evidence, circumstantial evidence. Correct answer here is option C, that is secondary evidence. Question number 554. An item of evidence which is not a secondary evidence is copies made from the original, copies compared with the original, oral accounts of the contents of a document given by a person who has himself seen it, counterpart of the document against the person who executed it. In question number 554, correct answer is option D. Counterpart of a document is against the person who executed is not a secondary evidence. Question number 555. Which one of the following sections of the Indian Evidence Act provides for the admissibility of secondary evidence? Here correct answer is option D, that is section 65. Question number 556. Secondary evidence of the contents of a document is not admissible when? Correct answer is option D, that is the original has been found to be inadmissible. Question number 557. In which of the following secondary evidence is relating to a document cannot be given? Option A, when the original document shown to be a possession of the person against whom the document is sought to be proved. Option B, when the original document is in the possession of the person who wants to prove it, when the original document is lost without any default or negligence on the part of the person who wants to prove it. And option D, when the original document is of such nature which cannot be easily moved. In question number 557, correct answer is option B. Secondary evidence relating to a document cannot be given when the original document is in possession of the person who wants to prove it. Question number 558. In which of the following cases secondary evidence of the contents of the documents cannot be given? Option A, when the original is in the possession of the person out of reach of the process of the court, when the original has been destroyed, when the document is registered one and may be produced before the court, when the original is of such nature as not to be easily movable. Here correct answer is option C, that is when the document is registered one and may be produced before the court. Question number 559. In which of the following cases secondary evidence may be given of the existence, condition or contents of a document? Option A, when the original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved. Option B, when the original is shown or appears to be in the possession or power of the person out of the reach of the court, when the original is shown or appears to be in the possession or power of the person not subject to the process of the court. In all of the above cases. Here in question number 559, correct answer is option D, that is in all of the above cases. Question number 560. A sues B on an agreement and gives B notice to produce it. At the trial, A calls for the document and B refuses to produce it. A gives secondary evidence of its contents. B seeks to produce the document itself to contradict the secondary evidence by A. Option A, he cannot do so. Option B, he can do so with the consent of the other party. He can do so with the order of the court, both B and C. In question number 560, correct answer is option D, that is both B and C. He can do so with the consent of the other party. He can do so with the order of the court. Question number 561. In which of the provisions of Evidence Act special provisions as to evidence relating to electronic record was added? Correct answer here is option A, that is section 65A and 65B. Question number 562. Which provisions of the Evidence Act relate to admissibility of electronic records in evidence? Here correct answer is option C, that is section 65 and 65B. Question number 563. In which section of the Indian Evidence Act special provision is mentioned regarding evidence relating to electronic record? Correct answer is option C, that is under section 65A. Question number 564. Under which of the following section of Indian Evidence Act the contents of electronic record may be proved? Here correct answer is option B, that is section 65B. Question number 565. Special provisions as to evidence relating to electronic record were inserted in the Indian Evidence Act 1872 in the form of section 65B with effect from 1710-2000. Question number 566. This presumption that a computer output shall be taken to have been produced by a computer is contained in. Correct answer is option C, that is section 65B subsection 5 clause C. Question number 567. Under subsection 5 clause C of section 65B in Indian Evidence Act, a computer output shall be taken to have been produced by a computer, whether it was produced by directly or with human intervention by means of any appropriate equipment. Here option C is the correct answer. Question number 568. In the Indian Evidence Act, the conditions in respect of computer output to be deemed admissible in evidence as document contained in option A, section 65B clause 4, section 65B clause 1, section 65B clause 2, section 65B clause 5. Here correct answer is option C, that is under section 65 clause B subsection 2. Question number 569. A certificate under section 65B of Indian Evidence Act which was inserted by the Information Technology Act 2000 must contain the following. Here options are identification of the electronic record containing the statement sought to be given in evidence, describe the manner in which the electronic record was produced, signature of a person occupying a responsible official position in relation to the operation of the relevant device or management of the relevant activities, all of the above. Here option D is the right answer, which says all of the above. Question number 570. Which one of the following section under Indian Evidence 1872 has been inserted by section 92 and schedule 2nd of the Information Technology Act 2000? Correct answer is option C, that is section 67A. Question number 571. Under Indian Evidence Act, the provision of proof relating to electronic signature is contained in. Correct answer is option A, that is section 67A. Question number 572. For proving execution of a registered will, it is necessary to call at least 2 attesting witnesses. It is necessary to call at least 1 attesting witnesses. Not necessary to call any attesting witness. It is necessary to call the registrar. Here correct answer is option B. It is necessary to call at least 1 attesting witnesses. Question number 573. Under Indian Evidence Act, a document required by law to be attested can be proved by calling both the attesting witnesses, at least one of the attesting witnesses, any other person, a legal heir of the attesting witnesses. Here correct answer is option B, that is at least one of the attesting witness. Question number 574. If no attesting witness can be found, it must be proved that attestation of one attesting witness is at least is in handwriting, signature of the person executing the document is in handwriting of that person, both A and B, none of the above. Here correct answer is option C, that is both A and B. If no attesting witness can be found, it must be proved that attesting of one attesting witness at least is in handwriting, signature of the person executing the document is in handwriting of that person. Here option C is the correct answer. Question number 575. If the attested witness denies or does not recollect the execution of the document, its execution may be proved by other evidence under dash of the Indian Evidence Act. Correct answer is option D, that is under section 71 of the Indian Evidence Act. Question number 576. In which of the following documents would need to be compulsorily proved by an attesting witness regardless of whether its execution has been denied? Option A, registered general power of attorney, a registered sale deed, a registered will, all of the above. Here correct answer is option C, that is a registered will. Question number 577. Under which provision of law can court direct any person to write any words or figures for comparison of handwriting? Here correct answer is option C, that is section 73 of the Indian Evidence Act. Question number 578. In which of the following cases constitutionality of section 73 of the Evidence Act was challenged for violation of article 20 clause 3 of the Constitution? Correct answer is option A, that is State of Bombay versus Kathikalu. Question number 579. Who among the following can compare the disputed handwriting with the admitted writing of the party? Option A, the court. Option B, a handwriting expert. Option B, by anyone familiar in the handwriting of the person concerned, any of the above. Here correct answer is option D, that is any of the above. The court, a handwriting expert, by anyone familiar with the handwriting of the person concerned. Question number 580. Under which section of the Indian Evidence Act the court can itself compare the handwriting of a person? Correct answer is option C, that is section 73 of the Indian Evidence Act. Question number 581. When the court obtains a sample of handwriting or signature of a person under section 73 of the Indian Evidence Act 1872, the court itself may compare the same or may refer to an expert under section 45, cannot refer it to an expert under section 45, must refer the same to an expert under section 45. Here correct answer is option B, itself may compare the same, may refer to an expert under section 45. Question number 582. Which of the following section defines public documents? Correct answer is option C, that is section 74 defines public documents. Question number 583. Whether following documents are public documents relating to acts or records of acts of the sovereign authority, public record kept in state of private documents, both A and B, none of the above. Here correct answer is option C, that is both A and B. Question number 584. Which of the following document is a public document? Only the documents forming records of acts of the sovereign authority. Option B, only the documents forming the records of the acts of official bodies. C, only the public records kept in any state of private documents. All of these. Here option D is the correct answer. Question number 585. Which of the following is not a public document within the meaning of Evidence Act? Here options are decree passed in a civil suit, caste certificate issued by a competent authority, judgment of a high court, AGD certificate issued by a medical practitioner. Here in this question it has been asked which of the following is not a public document. Here option D is the correct answer. Injury certificate issued by medical practitioner is not a public document. Other options are the public document. Question number 586. Which one of the following is not a public document? Option A, a document forming the acts of a sovereign authority, a document forming the acts of official body, a document forming the acts of officer of the government of India, a document forming the acts of an employee of an education institution. Here correct answer is option D, a document forming the acts of an employee of an education institution is not a public document. Question number 587. Which one of the following is not a public document? Option A, an unregistered family settlement, a registered sale deed, judgment of high court, judgment of civil judge. Here in this question it has been asked which of the following is not a public document. Option A here is not a public document, that is an unregistered family settlement. Question number 588. Public documents includes record of tribunal, record of court, record of public officers, all of the above. Correct answer is option D, that is all of the above. Question number 589. Which one among the following statement is correct? A public document is a document which has been executed by a member of public, has been made public, has been addressed to the public in general, was executed by a public servant in public capacity. Correct answer here is option D, that is has been executed by a public servant in public capacity. Question number 590. Which one of the following is not a public document? Here insurance policy is not a public document, whereas letters between authorities, electoral list and order sheet in the judicial process is a public document. Question number 591. Which of the following is not a public document? Will, public records kept in any state of any private documents, judgment of the court, arrest warrant. Correct answer is option A. A will is not a public document, it is a private document. Question number 592. Which is not a public document? Documents forming the records of the acts of foreign country, documents forming the records of tribunal, documents forming the records of the Commonwealth, documents forming the records of will written by the governor or state. Here correct answer is option D. Documents forming the records of will written by the governor or state is not a public document, whereas document forming the records of acts of foreign countries is a public document, document forming the records of tribunal is also public documents, and documents forming the records of the Commonwealth is also public document. Question number 593. Which one of the following is not a public document? Option A, a document forming the acts of a sovereign authority, a document forming the acts of an official body, a document forming the acts of public officer of India, a document forming the acts of an employee of an educational institution. Here correct answer is option D. A document forming the acts of an employee of an educational institution is not a public document. Question number 594. Which is not a public document? Orders of a competent authority fixing price of commodities, an order issuing search warrant, a crop cutting report by collector, plaint or written statement in a suit. Here correct answer is option D. Plaint or written statement in a suit is not a public document. Question number 595. Which of the following is not a public document? Affidavit, judgment of the court, arrest warrant, will. A will is not a public document. Option D here is the right answer. Question number 596. Section 74 of the Indian Evidence Act deals with testamentary document, non-testamentary document, personal document, public document. Correct answer here is option D, that is public document. Section 74 of the Indian Evidence Act deals with the public document. Question number 597. Mark what is not a public document within the meaning of the expression used in the Evidence Act. Option A, the records of the Motor Accident Claims Tribunal. Option B, the registrar of private documents maintained in the office of sub-registrar under the Registration Act, the record of proceedings of the House of the People maintained in the Lok Sabha Secretariat. Option D, pronote executed by A while taking loan from the moneylender. Here correct answer is option D. Pronote executed by A while taking loan from the moneylender is not a public document. Question number 598. Which is not a public document? Record of tribunal, record of municipal board, memorandum of association of a company, none of the above. Here correct answer is option D, that is none of the above. Question number 599. Which of the following is not a public document? Records of a nationalized bank, a post-mortem report, a private waqf deed recorded in the office of sub-registrar, entries made by a police officer in site inspection map and site memo. Here correct answer is option B. A post-mortem report is not a public document. Other given options are related to public documents. Question number 600. A private document kept as a public record of the state comes under the category of public document, private document, both public and private document, none of the above. Correct answer here is option A, that is public document. A private document kept as a public record of the state comes in the category of public document.